Welcome, everybody. Thank you for joining. We're here for our webinar, The Key to Making a Strong Application for an ICT Work Permit. We have 125 people right now coming online as attendees, and overall, we have more than 520 people registered. So we're going to wait a few minutes for people to jump in, and then I'll get started with the introduction. Thank you, everybody, and welcome. Let us know on the chat. Hi, Mohammed. Where are you coming from? Saying hello. What parts of the world you are right now so that we can say hi. And then we'll wait a few minutes before we get started. Just so you know, on the right tab, we have people from Toronto, Dubai, Vancouver Island, India, Brampton, wonderful, Montreal. Ooh, a lot of people coming in. Just so you know, you have that chat on the right side, and also you have a tab that's called questions. We did receive a lot of questions when people registered, so we'll try to go to those as much as we can. Ooh, thank you, Katayon. Somebody says, I never want to miss Mark's session. That's amazing. Hi, Fahime. Rajesh from Calgary. Sarah from Toronto. Ayad from Mississauga. Great. 152. Also, I wanted to let everybody know, as people who registered and also attendees, as soon as the event is over, you're gonna receive an automatic recording from Livestorm, I believe coming from my email, so that you can watch the replay. And also, we're gonna be posting the YouTube link on LinkedIn, as we usually do, as a recap, so everybody can have access to it. And feel free to share it among anybody that you consider it to be useful for. Welcome again, everybody. People who are joining, we're here for the webinar, The Key to Making a Strong Application for an ICT Work Permit. A lot of familiar names. Karen Deep in Ontario, Ramin in Montreal, Stephanie in Kenya. Hey, Stephanie. Nader. Geneva. Hey, Nader. It's great to see you here. Thank you for participating. For those who are just logging in, we're waiting a few minutes to get more people online, and then we'll get started. We have 170 right now, and in total, we have more than 520 people registered. On the right-hand side, you're going to have the chat, and you're going to have also an option for questions. I see some of you already started using it. And on the chat, on the Everyone chat, you can ask any questions that you have. We're also going to be providing the information of our guest through the chat, so that you can feel free to reach out to him directly as well. I hope the email doesn't blow up, Mark. But that's a good thing. Great, so I think we have enough people already. Let's get started. Let me get organized. So let's get started. Welcome, everyone, and thank you for attending our webinar today about the ICT, or intra-company transfer. We're really excited. As I was saying, we have more than 520 people registered to this event. And this time we're actually talking about a topic that we had before in one of our webinars, but it's currently one of the most popular programs in business immigration. And we have a wonderful guest speaker that I'm going to be introducing shortly. This webinar today is our webinar number 10. That's amazing. During the pandemic, as you know, we started doing webinars among our partners here in Canada that became very successful as a way of sharing knowledge. Many of the shared insights here are coming, as you know, from experience beyond what can be found in legal books. And these are a great benefit to immigration professionals to share and grow together, which is what we like to encourage. I would like to first introduce myself. My name is Marianella Manzur. I'm the Director of Sales and Marketing here at Joorney Global, and I will be your host today. I'm an immigrant myself, originally from Colombia, and proud to be part of Joorney. I believe this time Joorney doesn't need an introduction. Today, we're not here to talk about us because most of you have already worked with us and know our values by heart. Today, we have some members of the team, including Tanya, our account manager. Hey, T. And we also have our wonderful marketing team members, Rachel. Hey, Rach. And Dragana. Nothing could be possible without you, and thank you for that. I want to just do a disclaimer, just a small reminder that this is a webinar intended to be from an immigration lawyer to other immigration professionals, including immigration lawyers and immigration consultants. For those who are interested in the ICT as applicants and are here with us today, feel free to listen in and reach out to our guest speaker today for more questions, or maybe reach out to your immigration lawyer or immigration consultant. Also, a very important note, Joorney does not provide any legal advice. We always leave that part of the process to our wonderful partners. We will be having our guests talk about the ICT, and at the end, we're going to have room for Q&As. So when you registered, you sent us some questions, so we're going to pick a few of those and try to answer as most questions as we can. And like I said, on the questions tab on the right-hand side, you can also ask an additional question if it comes up. Our guest today is a wonderful and knowledgeable immigration lawyer. I'm extremely excited to have him with us. I remember back in the day when Joorney started in Canada, that was around 2017, I received a call from Mark, kindly inviting me to participate as a guest in a podcast to talk about our business plans and other services. He was so kind and nice to give us this amazing opportunity and push, even at the time that we were only starting. I was so scared and nervous, I remember, and he helped me pull through what resulted in a very successful podcast, and then was one of the ways that we actually started getting business ourselves. So we are extremely grateful, Mark, for your support. And let me tell you a little bit more about Mark. Mark is an immigration lawyer. He's the owner of Holthe Immigration Law, located in Calgary, Toronto, and Ottawa. With the background of having been an immigration officer himself, Mark has been on both sides of immigration. Now he assists large and national and international companies and temporary foreign workers with their transition to permanent resident status in Canada. Mark speaks at the Canadian Immigration Podcast and weekly at his Canadian Immigration Live Q&A sessions on his YouTube channel. We are flattered that you accepted our invitation, Mark, because we know how busy and popular you are in social media and in the immigration space overall. Thank you, Mark. We are so happy to have you.
Thanks so much, Marianella. I really appreciate that. I remember very fondly when we did that first podcast episode. In fact, I pulled it up here on my computer. It was Wednesday, October the 24th, 2018.
Wow.
Yeah, it was a business immigration series that we were doing, and I thought, well, I'm going to bring in some vendors. And I think I'd seen you guys around at maybe some of the CBA conferences, and I knew from experience that you did great work, and so it was a no-brainer to bring you on, because lots of times people won't understand the value of a business plan until they get their work permit rejected. And this is a work permit that is not to be taken lightly. The whole intercompany transfer world, as some of the questions that came in that our attendees sent in advance, they were talking about, oh, why are these applications getting refused? Why are they not? Why are we not more successful with these? How to increase success? And that's really what we're going to talk about today, is how to try to strengthen your application. But you have to be real with these things. You can put your best foot forward and it can still get rejected. And I want to put a caveat out there as well, Marianella, that I've done this for since the beginning of my practice, probably I guess 18, 19 years, but I'm still learning. And I definitely do not pretend to know everything there is to know about this. There's nuances in visa offices all over the world. So what I'll try to share the limited knowledge that I have about this process, and having worked with global companies for years and years, and probably I've done more intercompany transfer work permits than anything else, probably even more than LMIAs actually.
Wow.
The world shifts. We're post-pandemic. These officers are getting accustomed to this stuff again. And as Canada starts to recover from its the doldrums of the pandemic, and as our economy starts to heat up, these types of work permits are going to become more and more popular with our overseas clients. So
Definitely, Mark. Thank you so much for accepting our invitation. And this is what I love about our webinars. It's not the law, the legal specific requirements that we need to know about the ICT, but it's also what are we experiencing on a daily basis? What has happened to me that maybe you can benefit from knowing about that? So just sharing the knowledge, being able to grow, to learn together. I really appreciate to have guests that can help us with that initiative. So if you agree, Mark, we can jump right to the questions and get started on those.
Yeah, let's do it.
Let's do it. So just to get started, let's start with the basics. Can you give us a brief overview of what the ICT work permit program is?
You bet. And so one thing I want to emphasize is that the government website has a ton of information on it. The program delivery instructions, the instructions for the general intercompany transfer provisions, as well as those for the treaties like CUSMA, we call it now, and GATS. So the government Ircc website, I am not going to sit here and read to you guys exactly what you can go on and read yourself. So when you're getting, if you're even thinking about doing this, you need to know everything that the government knows, everything that their officers are looking at when they're doing these. So you have to do your work. It's not a case of just filling out the generic document checklist that's online. These work permits require a lot more work. They require a lot more of this. You're really pondering and thinking. You have to get to know your companies so that you can really advocate on their behalf, because most of the work on these are not done just filling out, the overseas application forms and providing the bare bones documents that are listed in the checklist. If you're doing that, you're doomed for failure. These require a detailed understanding of what the officer is actually looking for, because letters that you draft on behalf of your employers that are kind of like a cover letter, those are as important as anything else in the application. So that's a little caveat at the beginning. And so what we're going to share, I'm going to talk about my experience. We're going to talk about the insights that I've gained over these years of practice. And you may have other experiences. I may say, this will never work. And you'll say, I had to work twice, right? Or someone will say, I've never been successful with that. And I'll say, I never get those refused doing it that way. So there is a wide variety of ways in which you can do it. But the one common theme is you have to be prepared to do your work. So what is an intercompany transfer? Well, it is exactly like it sounds. You are transferring someone from a foreign entity to a related entity in Canada. And we'll get into the kind of dynamics of it, but essentially that individual is going to be taking up a position in Canada where they already have experience with the foreign company, and they're bringing their knowledge and their skill and their understanding to Canada in such a fashion that maybe the Canadian entity doesn't have those skill sets, and they're related companies. So this is an employee moving within a global organization. So if you think of it that way, that's the best starting point. You've got managers and specialized knowledge people that fit within those categories. And Canada breaks it down into two varieties, I guess. There's R204A, which is the general kind of provisions that applies to all over the world. So because most countries have similar provisions, Canada says, okay, we're fine with you having a company in a different country, a related company, subsidiary, a branch in Canada, and moving people back and forth, because we know that other countries likely to allow our Canadian employees to go there. So there's kind of reciprocity, and that's why this, competitiveness internationally, Canada wants to be in that game. They don't want to restrict growth globally with the international markets. So they're fine with people coming in, but they also know it's subject to abuse. And so there's very narrow parameters. So R204A is for the general provisions. And then we have, those are what we call the C12 for the confirmation exemption codes. codes. And then we have the R204As, which are they're the treaties. They're like CUSMA, which used to be NAFTA, and the other treaties that we have with other countries. So you always want to make sure that you look at the specific provisions for each country, and because there are slight variations with who can qualify and the requirements based on the treaty side with the T24. So always go back and look at those. But what I'll be talking about generally is the C12s today, and touch a little bit on the T24s as it relates to CUSMA, which is the ones where we mostly see happening. But yeah, this is kind of the overview of what an intercompany transfer looks like. And yeah.
Great, Mark. So so we usually get a lot of questions. People are asking, does that fit my company abroad, or the company that I work for abroad? Does it have to be a huge multinational company? What types of applicants usually fit this visa type?
Yeah. The bigger, the better. Simple as that. So if I have a large global company with 1,000 employees and branch offices in multiple countries, and they have a well-established branch in Canada, that, my friends, is a slam dunk. That's a pretty easy argument to make on a number of levels. The smaller the company, the more difficult it is. The lower the annual revenues, the more difficult it is. And so, there is no real minimum threshold in terms of how big a foreign entity needs to be. But when it comes to an intercompany transfer, yeah, the smaller the entity, the more difficult it is to make that case.
Okay, and that's good. In what has to do with the business plan side of things, we usually see on the personnel plans that people focus on having at least 3 levels of hierarchy regarding the company that they plan to have in Canada, showing that it's not going to be maybe one person and their assistant, but that it's actually going to be an organization that is going to also be generating jobs, and also making sure that it's nothing that is a small plan.
Yeah, that's exactly right. And there is no fine line, like I said. That I've done intercompany transfers for an individual who has had a few employees in the home country, and he or she themselves want to transfer to Canada and set up a new operation in Canada, and I've been successful doing that. Just as important as the structure of the company, the size of the company, is where the person's coming from. So there's a big difference transferring someone from India versus the United Kingdom, right? There's a big difference with visa required countries and visa exempt, because with these work permit applications, they're under the International Mobility Program, and individuals that are coming from visa exempt countries can apply directly at the port of entry for these work permits. And for global companies, we do that all the time. They complete the biometrics at the port of entry. And so the standard that you have to hit is also affected by where these people are coming from. And so if you are coming and having to apply through a visa office, the amount of effort and work you have to put into one of those online work permit applications is way more, because the officers have a whole lot more time to look at it, scrutinize everything, make sure every T is crossed and I is dotted. Whereas when you have a Canada Border Service Agency officer and you're flying in and you've provided your worker with a packet to apply for the work permit right at the POE, well, those border service officers, they don't have as much time. There's a whole flight coming in, and they've got lots of people going through, and when you're referred back, there's a big lineup, so they don't have a lot of time to look. And so we're very strategic with how we prepare those packages, so that the officer has everything that they need right in front of them. And like I said, the bigger the company, the easier the easier the approval is often. But when it's a little bit smaller, you have to really, really make sure that all of the parameters of the work permit are very easily met. And but yeah, size, even when they say it needs to be at least 3 levels, there's a difference between the 2 kinds of transfers, right? You have individuals that are senior managers or executives, and in that case, org charts are super important. If a person is too far down the food chain, then they start to wonder if this person is really a manager in the sense that was intended for intercompany transfers. The bigger the company, maybe I've done functional managers. I've done managers that are at a 0 level for companies that are really large, and they might be 6 or 7 steps down from the CEO or the board, right, or the president of the company. But then I've had other situations, like I said, where the owner of the company themselves is transferring, and they own both of the companies. So they are the connecting link, and they're the ones moving. So that's traditionally how I approach it. But yeah, there's so many different variations and things that you have to take into consideration. And as a representative, it's your job to sift through all of this and put it together in a way that an officer says, yeah, that looks like a legitimate transfer. And it's not just solely for the purposes of securing immigration status in Canada. So, yeah.
Thank you. Thank you for that, Mark. And you've been touching a little bit, and I'm going to go to one of the questions that we have further along. What are the steps when an applicant wants to apply for an ICT? And you were mentioning like 2 types depending on if they were visa exempt or not. So it would be great to go into that process.
Yeah. So just like all work permits under the International Mobility Program, there's a requirement to register that job offer in the employer portal before you start the process. That's kind of step 1. Although, as of, and I'm trying to remember what the date was that I just got this, I was looking at the regulatory changes. Let's see, I've got the slide deck from immigration right here. Yes. So coming into force on September the 26th, which is 4 days from now, employer compliance is tightening up. And when our job market starts to heat up, the concerns about fraud and misuse of the program start to tighten. So they are adding more levels to the intercompany transfer and other international mobility program work permits than they have in the past. And one of them is an actual signed contract, which becomes a little bit challenging when you have an international company that's just moving one of their workers internally. They're not signing a new contract. So we're now struggling with how we're going to advise our global clients, because they actually require that a contract be signed, an employment agreement. And so that's really kind of step 1 is figuring out, obviously you're going to assess whether or not the individual is eligible for the program. And I guess maybe, Marianella, we could take a little step back and just talk about, before we jump into how to, maybe we can just talk about the essential components. How does that sound? Just
Definitely,
so that people
let's do that.
look for those parameters. So if you look at, generally speaking, and this tends to apply these basic components to most of the C12s, the general provisions, as well as the T24. So, you need to have an international company. Like, it needs to be multinational. You need to have a company in both places. If the company in Canada is not set up yet, yes, there are some startup options which business plans are essential for, but I won't touch on that yet. If you have a company that you want to transfer someone from outside of Canada, and they're transferring to a parent or a subsidiary or a branch, so it could be the other way around. The Canadian company could be the parent, and they could have a subsidiary, a branch, or an affiliate abroad, or vice versa. You need that corporate relationship to be there. Now, like I said, I've had smaller companies where one individual is kind of at the top, and then they're wholly owner of 2 other entities. So you can have those situations, but there needs to be at least, I always approach it like a 51%. There needs to be a kind of a controlling interest to establish that relationship. So when we're structuring it, we want to make sure wholly owned subsidiaries are the easiest to deal with. And that's how I usually advise people, but that needs to be in place. And then the person themselves that's transferring, they themselves need to be transferring from a similar position. So you can't take someone who is working as one of your awesome technicians, and then you say, I want to transfer you as the manager of the new operation we're setting up in Canada and to help, spearhead it. It actually doesn't work that way. So you need to be transferring from a similar level position. And on that note, like we touched on briefly, it needs to be in an executive, a senior managerial, or specialized knowledge capacity. And the whole concept of specialized knowledge is a webinar in and of itself. But essentially, the person has to show an advanced level of knowledge with some proprietary aspect of the company. And I'm really simplifying that, but the Ircc website has a lot of detailed information. And one little pro tip I'll toss in here, Marianella, for our listeners, is that you need to bake into your letter, and I always draft a letter on behalf of the company. I don't do it on my letterhead. Even having worked on the border as an officer, when they look at our letters, you guys, they just kind of set them aside, and they just want to dig into the meat of the material. And so I 100% build my information, the explanations into the letter that is being presented from the perspective of the employer, so the employer letter. And that submission letter, I call it, is really the foundation that gives the roadmap for the officer of why this person qualifies. Background information on the company, background information on the individual, the transfer, what they're planning on doing in Canada. And so these components are really, really essential. Okay, what else do we need? Well, the operation that the person is being transferred from can't shut down. It needs to exist. So it needs to truly be a situation where the person can transfer, because this is temporary, right? Just like every work permit, and then be able to go back to that entity once that assignment is done. That's kind of the general provisions that you're looking at. And the person that's being transferred has to have been working continuously for at least 1 year in the previous 3 years for the company. And I'll put another caveat there, because some people say, well, what if the person worked, well, a year ago and they haven't been working for the company, and now I want them to come back and transfer? Well, in that situation, yes, you only need 1 year of continuous. But if they haven't been employed recently with the company, then I will put them back on payroll for that company before I make the transfer, the foreign entity. So you've got the individual, you've got the corporate relationship, you've got an individual that's executive, senior manager, or specialized knowledge. They have to have been working for at least a year in the company abroad, the foreign entity, and they have to be transferring in, into a position that's a real position. So they have to actually be taking up a role in the Canadian entity where the Canadian entity is controlling them. And we do a lot of work for cross-border companies, US and Canada, and there's a lot of people that parachute in, and work on some projects and then go back. And so in those situations, it's going to be a little bit more challenging now, but they always need to be actually taking up a position in Canada. So that's a really high level of how it works. And then the last little piece, like I hinted at, is when you're submitting the application, you can do it two ways. If they're visa exempt, then in some instances you can submit the application right at the port of entry. So the individual has their electronic travel authorization, and you prepare them with this package that they take, and then they fly into, I only tend to do these in Toronto and Vancouver, because the legacy officers, when the whole CBSA rolled over from immigration officers years ago, the places that see the majority of the intercompany transfers are the major ports of entry. And yes, Montreal is fine as well. But yeah, going through this process is really, really critical that you know where you're applying, who you're presenting it to when it comes to the visa exempt folks. And then everybody else, you're stuck with applying online, and it's going to be a lot more work, but that's just the nature of the beast when you're bringing someone in from a visa required country. So that's,
thank you, Mark. Thank you for that. Yeah, that's great, because we needed the recap to make sure everybody's on board with the basic requirements, and thank you for that, Mark. About some of the things that you were mentioning, it's great that you did talk about the fact that one of the things that needs to be argumented in the application is that not only their position that they're going to have here in Canada, but the one that they previously had. And that's part of what we also mentioned in the business plan. So we need to do two arguments, right? One is, what was that person doing before? Did they have an executive and managerial role back then? And then what is going to happen in Canada, and why is it important that they come instead of maybe a Canadian citizen or resident, right? Exactly. So that's a very important part of it. I know that you're not going to like my next question, but I encourage you to be as honest as possible, because we want to hear from you, like, with no filter. How long does the application, right. Exactly. How long are these application processes usually take?
Yeah. So, okay, we know what the world is like here with immigration. The processing times are all over the map. Prior to the spring, I would say, I'm trying to remember when it was. I think it was February. I'd completed my term as the national chair of the Canadian Bar Association's immigration section. I transitioned to immediate past chair, and in this past spring, well, I think it was like February, maybe the beginning of February, myself and some fellow table officers, we met with Minister Fraser And one of my key messages to him was, stop posting processing times that are not accurate. It's not helpful to list your service level standards and then leave people hanging, not knowing how long it's actually taking to process their applications. And that was the last message that I drilled into him, aside from all the other things, like just redo the 18-month post-grad work permits and, and start doing draws and those kinds of things. Well, this was a key thing that I wanted to drill into him is, look, we need, as business owners, our employers, as individuals, they need to have some level of predictability as to what they're going to get when they start the process. Like it's hugely important to know how long things are going to take, so that you can make legitimate business plans. Like, what good is a business plan if you don't have some form of a timeline as to how things are going to roll out? You have to plan for cash flow. You have to plan for just the time it takes for regulatory, approvals and things like that when you're setting up new entities and corporations. And if you don't know how long, work permits are going to take, this is just, it makes it impossible to plan, right? And so the minister, he said, I get you, I understand. And after that, we saw a shift away and trying to be more transparent. So how long does it take to do a work permit? Well, they don't distinguish intercompany transfers from LMIA-based work permits or others. We know that some programs like the Global Talent Stream and others are designed to be more fast-tracked. But generally speaking, what do? I go to the Ircc website. I type in work permits. I pull in the drop-down menu. I find the country, and then I look and see what it says there. And then I tell my clients, well, generally speaking, this is what it looks like. So this is what you should plan for. Now, sometimes we get surprises. Sometimes things come back a lot faster. And then, wow, one piece of advice I'll give you when you're working with employers or anyone really, under promise and over deliver, which essentially is doing exactly the opposite to what IRCC is doing right now and our dear minister, unfortunately. So so processing times, they're all over the map. And the beauty of going through the process for visa exempt candidates is that I can have a company call me today, and we've got our systems pretty slick. I can have them call me today, and as long as they're fast, we could literally have an individual on a plane flying to apply for their work permit tomorrow. And when there was a time when job offers weren't required to be registered, and I would get calls when the person was actually on the plane, and I'm like,
oh my God.
And then we'd whip things together. We'd make sure they had something on their handheld phone, or we would try to fax it to the port of entry. Fortunately, for my sake, those days are gone. But you can do it really quick when it's a visa exempt individual. When it's visa required, you're subject to the processing times. With the job offers, I will say that those are pretty instant. So when you submit the job offer, you register it, it's a pretty instantaneous process. Kind of like the electronic travel authorizations are also pretty quick, unless there's some issue that trips you up. But that's generally what I tell. So long answer to basically say, meh.
Nobody knows. Exactly. But I appreciate your honesty on that, Mark, because I rather we are transparent, and I think that's a message, like you were saying, to all immigration professionals, right? Tell them the truth and let them decide if they're willing to wait or not. And if you're lucky, you'll get it before, right?
Yeah. And Marianella, one thing I will add for those who are attending today: resist being bullied. Okay, you have companies that are under tight time frames, and they want exact dates, and they want to know because they have to make plans. Do not overpromise. Do not cave and say, oh yes, we should be able to get it done in 3 weeks. It could take longer, but we'll shoot for 3 weeks. All they hear is 3 weeks, and everything is planned on 3 weeks. And the project then kicks off, and then you need to transfer someone, and you've told them 3 weeks. And if it doesn't come in 3 weeks, which by the way, you have zero control over, everyone, then who's the bad guy? So you're far better off to say to them, look, we will do everything in our power. Right now, the processing time show 3 weeks. We will show this to you. It was last updated 2 days ago, but we cannot confirm. So do not make any hard and firm plans until we know we've got the approval for that individual. So always manage the expectations of your clients, because if it doesn't work out, it's going to be on you, and you're going to have an unhappy client. And then, you're going to lose them.
Yes, definitely. And I think this is one of the takeaways of the whole webinar. Because I mean, anything that has to do with processing time.
Yeah. Tips, right? Yeah, that's a takeaway. Mm-hmm.
Amazing, amazing. Mark, and in your position, you of course see trends as they're happening, and it happens to us as business plan writers as well. Last year, starting the year, we were doing hundreds of LMIA owner operators, and today, I mean, we're doing maybe a couple of people who are wanting to apply through the owner operator. But now we're doing a lot of ICTs. So I wanted to ask you, why has it become more popular recently versus other business immigration options?
Yeah. So if we go back to, I don't know, maybe 2014, when then Minister Kenney basically shut down a lot of the investor and entrepreneur options, that was always number one, right? Someone who wanted to come to Canada and didn't have other options, but was successful with their business in their home country, and had resources, they would go through the investor and entrepreneur programs. And then those kind of fell out of favor. Why? Because of fraud and misuse and abuse. And I'm just like, because those programs were good, but whenever there's good programs, there's sketchy people that are looking to take advantage of them and abuse them, and then it spoils it. So then we went to the LMIA, owner operator, brilliant program, loved it. Abuse, the fraud that exists within it, and it just makes me so frustrated and so angry. And then when IRCC realizes they can't get a handle on it, then they shut it down. So the tried and true ad exempt owner operators, which was beautiful, are gone.
Yes.
So can you still do an LMIA for an owner operator of a company? Yeah, but you have to advertise for the position, and that's why it's slipped away. So I remember sitting in those meetings with government when they were talking about this, and I remember presenting to ESDC in one of our national meetings, and I think it was 3 years ago. It was before the pandemic. I think it was 2019, that fall. And they were talking about their intention to shut down owner operators. And I was like, and they were very transparent with us. It was fraud. It was misuse and abuse of the program. And so owner operators, that's another reason when that avenue shuts off, then where else do you go? The next thing is intercompany transfers. So basically, people are trying to find ways that don't require an LMIA, well, in the true sense of advertising. So all of the international mobility work permits are fair game, and the intercompany transfer is the next best option that's available to assist people that are looking to, establish a presence in Canada, invest in Canada, and potentially immigrate to Canada. And with the competitiveness within express entry and the inability of some people who are older, who have more business acumen, who have more work experience, well, your human capital is just so low that it's unlikely you're going to be able to qualify through express entry. So you need to have that Canadian experience, and an intercompany transfer work permit can provide an opportunity eventually for extra comprehensive ranking system points to bump you up in the rankings. And if you're an executive, that's 200 points, right? A 00 executive. So, and those tend to be the individuals that are transferred with an intercompany transfer.
Thank you, Mark. Let's jump to another question, more related specifically to the ICT. So what is the business qualifying relationship in ICT?
Yeah. So like we talked about, we need controlling ownership here. So the entity that is in Canada or abroad, that relationship needs to be that of a subsidiary. It could be wholly owned, but it has to be a majority controlling interest. It could be a branch office. It could be an affiliate relationship. And, typically when we have new startups where, like I said, those business plans become so critical, they're essential. You're never going to apply for a new startup intercompany transfer unless you have a business plan in place. But in those situations, wholly owned subsidiaries are great. But as long as the entity, the connection between them, there's an ownership and there's a controlling interest of at least 51% is kind of what I look at, then it won't work. But the company needs to be actually an entity in Canada. So you can't just parachute someone in without there actually being a company that is there registered as an affiliate branch or subsidiary.
Definitely. And how long is the initial work permit valid for, and can it be renewed?
Yeah, so this is a great question because it depends on what you're asking for. So when it's a startup situation, they only issue it for 1 year because they want to see, hey, is this actually going to pan out? So we'll grant you this 1 year, but we want to reassess it right away to see if you've actually followed through with what you've presented in your business plan. And that's why those business plans are so important, and the importance of making them realistic and achievable. And so for that, they tend to restrict them. For individuals who are maybe not necessarily transferring full-time in Canada, they tend not to issue longer-term work permits for those individuals. They tend to be, 1 or 2 years, depending upon, what the purpose of the transfer is. For individuals that are transferring from into Canada to actually work full-time out of that Canadian operation, we often see that they are willing to grant up to 3 years for that initial work permit. But once again, what does the plan say? What is the business? What's the projection? What's the expected role that they're going to fill? So 3 years, up to 3 years initially. And I always qualify this, you guys, because I've seen some crazy things at ports of entry. I've seen officers issue longer work permits. I've seen them issue shorter ones. And same with the visa office abroad. You put in what you would ask them to, kind of your wish list of how long you want them to be issued for that initial one, but they'll decide. And then when you break it down to how long they can continue extending those, that depends upon how they entered. And you have to determine. You can't say, well, I think they're a senior manager, but they also have specialized knowledge. No, you need to pick one. And if it's senior managerial or executive, the person can be in Canada up to 7 years in a row. And for specialized knowledge, it's 5 years. Now, the interesting part, Marianella, is that you have the ability to recapture time. So if an individual has been coming to Canada and then going back, and they are moving back and forth between the company, and you track those entries and exits carefully, you can actually work it such that only the time that they're physically in Canada will work to eat away the full time period. And so you track it, and if the person has hit the 7 year mark as a senior managerial, they've traveled a lot back and forth, then you can make an application. You can present the evidence showing, well, they were only here this time, and then one time they will let you recapture for the balance of whatever time. And that's one advantage that people need to be aware of. So track your exits and entries after that work permit's been issued.
And Mark, about what the officers decide to be that valid time, do you think it's good because it adds accountability to the program itself, like making sure that they're really going to do what they're saying they're going to do, right?
Yeah, and this is really important too, and sometimes it gets glossed over. Employer compliance is a reality, you guys, and lots of people are reluctant to wade into this world because of having employers saying, well, what's my risk? What are my liabilities? What in terms of employer compliance do I need to do to make sure that I'm not going to be fined or have some embarrassing news report on CBC talking about how I'm not treating my workers right? And so employer compliance is a critical component to this. And so many employers, excuse me, if a worker doesn't work out, they're like, well, whatever, fine, who cares? Well, you can't treat it that way. If the worker leaves, you actually have a duty to notify Ircc that they're no longer working for you. Because if an audit comes, and it will for companies who are, applying for work permits, whether it's the Temporary Foreign Worker Program or the International Mobility Program, they will all receive, have the experience of going through basically an immigration audit, a compliance review. And so you need to make sure that documentation is all set up properly, and that if a person leaves early, that you notify them. Otherwise, you could be found non-compliant.
Okay, that's great to know. And now that we're talking about things that can go right and can go wrong, what other challenges have you faced with these applications, Mark?
Yeah, so this is just discussing this. It could probably take the next 30 minutes of the presentation of 45 minutes. So there's a lot of things that can go wrong, and it's hard to isolate just one thing. But like I said, the larger the company, the more slack they're going to give you. So what evidence do you use to prove the corporate relationship, right? That's one question you ask. What evidence do you bring forward to prove that the person has specialized knowledge, or that the person is a senior manager or an executive of the company? Well, intuitively, you know that, pay slips, and, if the person's coming from the US, they have W-2s, which are the equivalent of our T4s. So there's tax records and things like that can be used to show where the position the person has. The letter from the company is vital because it breaks down all of the details that the program delivery instructions say an officer needs to look at. And so that's why those letters become so good. And there's no right or wrong way of doing it. But I literally structure in that letter a table at the very front page that breaks down, this is the category we're applying for, this is what this is the individual, this is the knock code, and this is another tip. And maybe this is my second, real huge takeaway, yes, is that so often when I'm doing express entry, especially for employees of international companies who other counsel has done the original work permit, there's a tendency to be lazy and just kind of lump everybody through as a software engineer, right, or a software developer. And then what happens is, if they're not, and when I'm going through the process, the most difficult part is that Ircc does not scrutinize the knock codes as tightly for these types of work permits as they do for express entry. So someone will have gotten a work permit as a 2172 or whatever it is, and then I'll go through and I'll look at the job description. I'll say, no, you're actually a 2173, but you've had a work permit for that other knock code. Your work experience in Canada, which we need, is under one knock, and it's not correct. And I've seen Ircc refuse express entry applications because of the wrong knock when the intercompany transfer was issued. So under a separate knock. So you need to be really careful and actually do the due diligence to make sure you're selecting the proper knock code, and not just doing the same thing that you've always done for the company because, hey, everybody is, we're getting approvals with this. So that's one issue where I see problems arise. But generally speaking, the challenges arise because you have not done a good enough job, and the onus is on you as the representative to make sure that you're confirming and establishing the corporate entity and the corporate relationship. So incorporation, certificates of incorporation, share certificates, stock certificates showing the ownership of the companies. With larger companies, I will sometimes go to their annual reports, and they have lists of subsidiaries, in the later appendices of those reports, and I'll use those in some instances to demonstrate that that this is a wholly owned subsidiary of this large parent company. So on the corporate side, we'll often do that, the Canadian registration, the certificates of incorporation, things like that. So that's typically where we show. And it becomes challenging when you have multiple levels and there's a lot of subsidiaries, and you have a parent company, and then they have a subsidiary who's in, let's say, India, and then this entity is a wholly owned subsidiary of the sub company in India, and the parent's in Denmark or something. And so your job is to show that. So corporate flow charts are really helpful, showing, how all of the entities, fit in. And that's how I deal with that. When it comes to individuals themselves, reporting structures and showing how this person fits into the reporting chain. So we build those out as well. So all of those things, things tend to fall apart when you haven't done a good enough job of making the case for why this person truly is a senior manager. And there is no right or wrong way to do it. It's just your advocacy skills and how well you can write, how well you can present that information. So I often see those as being issues. Another issue is it's kind of like a smell test, is the way I describe it. And you only really understand it as you start to do more and more of these. But there are certain provisions in terms of things like wage where it just doesn't make sense. And I saw one of the questions that one of our listeners had posted about how, what if you're the owner, but you've been investing your, the revenue back into the company and you haven't been taking it as a wage? that's one of the most common problems when we have smaller entities looking to transfer. So I'll give you a practical example. This is one, I've had very, very few intercompany transfer applications refused. Like I can probably put them on one hand. But this company was based in the UAE. It was Pakistan, citizens of, Pakistani nationals. They had an IT company. Actually, I think it was a social media marketing company, but their annual revenues were, they were like probably $1.4 million, and it was a family business. And they wanted to transfer the one brother to Canada to help initiate the process. They had gone on exploratory visits. They had met with, with the business and the business associations and the startup entities, things like that, the incubators and the supporting, the corporate kind of supporting organizations in Ontario. I can't remember the names of all the ones they went to make sure they're doing their diligence. They had a good business plan, and everything was solid except for his wage. And in the company, everybody shared everything. It was a family-owned business. They, no one person had, substantial amounts of money that they're being paid, because it was all being reinvested in the company. And when they were sending him over, they only wanted to pay him as a senior manager, $45,000 Canadian. They didn't want to do anything more. And I warned them and I told them this is going to be a problem. They're going to question it. And sure enough, the application got rejected because the wage that was being paid in Canada wasn't commensurate with what was expected for a senior managerial position. And sometimes we see that, for example, transfers that are coming from India. If you're transferring that person to Canada, it better be at the prevailing wage rate at a minimum. Otherwise, it's just going to get rejected. So that's another area of challenge for sure.
Thank you, Mark, for sharing that. And now that you've touched on the fact that a lot of your applications have been approved, do we have the possibility of knowing what the success rate is for the ICT applications in general?
Yeah, that's a great question. It's actually fairly high, higher than you would imagine. At least the statistics tell us that. I managed to track down, and this by no means is official. Okay, this is just anecdotal kind of experience. So in my experience, the approval rates have been above 80%. Ports of entry, for example, like I have never had one refused at a port of entry. I'd like to think it's because I do a good job, and having worked as an officer, I know what they're looking for. But ports of entry, if I have all the elements there and I present it, and let's face it, I also do not submit applications that I know are not going to get approved. But ports of entry, the rates of approval are really, really high if you've done things properly. Embassies and consulates, and please understand that approval rates are often really, really tied to the visa office itself. An intercompany transfer coming from Africa, like I said, compared to Australia, completely different worlds. But generally speaking, embassies and consulates are around 89%, and then inland applications for extension. This is the irony. Sometimes there was a time when Vegreville was actually the processing center, and things were all great. And then it moved to Edmonton, and there was this shift in approach. And I'm almost positive when you have a bunch of new officers, they apply things a lot more strictly than ones who are seasoned, who've seen a lot. And that's why I like the ports of entry, because often the officers adjudicating these have seen a lot, and they're like, sure, it's not an issue. But the Edmonton Inland Processing Center, it's probably about 88% or 87%. So the rates of approval are high, but this is general. This is across the board. And I don't want to give people a false sense of security, because clearly, I don't have specific statistics for India, but guaranteed those approval rates are significantly lower. So it just depends on that source country. But let's face it, I don't care what the approval rates are. I don't. At the end of the day, my job is to make sure that this qualifies. And if it qualifies and an officer refuses it, I'm not going to roll over. I'm going to challenge it. I'm either going to request reconsideration, I'm going to escalate it to the program manager, and I will keep fighting, or if I have to, we will file a leave application. So part of the reason I'm not concerned about things getting rejected is because I know that I've included everything in there, and that there is no reason that it should be refused. And if it does get refused, then I have a discussion with the company, and we will fight it.
Great. Thank you, Mark. And that being said, I mean, there's a lot of people who are attending this webinar that either have a lot of experience with ICTs or some people who don't have a lot of experience. And one of the things that I like of most of the guests that have been in the webinars is that they usually provide services for people who want to play it safe, to go with somebody who's knowledgeable, to make sure that they work with alongside somebody like you. So I wanted to ask you, how do you usually help other immigration lawyers or immigration consultants with their ICT applications if they have clients for those?
Yeah. So when I first started practice, I was called to the bar in 2005. So I started 2004 as an articling student with the law firm Gowlings in Calgary. And I had worked on the border and I understood kind of the mindset of officers, but I didn't know how to put together a letter of support from an employer. And so fortunately, I had a great team of other business immigration lawyers, in our offices. I was in Calgary, in our offices in Toronto and Waterloo, and I'm still very, very good friends with them, who kind of showed me the ropes. And it got me, on track. And then the more you do, the better you get. And I had some experience working with some global companies. And I was able to see what other practitioners were doing when they would win RFPs. And then I'd be doing all of the extension applications. And as they changed, immigration service providers, I would get all of these chances to see what other people were doing. It was wonderful. It was amazing. It actually boosted my confidence significantly. Because sometimes, as the operations get larger and the immigration lawyers at the top or the consultants at the top have less, oversight over the actual day-to-day work, then the quality starts to go down. And it was wonderful for me because even as a brand new lawyer, I was like, holy crap, like my applications are way better than this fancy hotty-totty lawyer in Toronto, right? Mine are way better. And I think it was because I was so freaked out. I didn't want to get it refused being a young lawyer at the national firm. I couldn't afford, like the companies, too much was counting on it. So I went crazy learning everything I could. So with that being said, flash forward to today, I've actually changed my model significantly. So I don't have paralegals anymore. We don't use them in the firm. And at the same time, we've taken the approach of being collaborators with our clients. And that goes the same for other people that we're working with. So for my companies, I work with them and I teach them. And yes, it's probably not a great business model, but our goal is to build relationships with the companies so that they will continue to use us over and over for years and years. And by collaboratively teaching them and assisting them and then helping them to drive their own ship forward, we find that it's awesome for us. We cut out all the middle people. I don't have to worry about a paralegal missing something or some support staff. And I always know that what's going in is going to be approved and I can sleep at night. So when we work with other practitioners, essentially we do the same thing. So if, I don't, like, I've never really called it co-counseling, but I guess that's what some people do. If someone wants to work with us, then I will work with them and, and we'll settle on a fee and I will teach them as we go through the process with their clients. And for years I worked in that type of relationship with global companies when they were outsourcing the work to me. We worked collaboratively. And how we structure that is as varied as the person, and however much or however little support they want. Sometimes consultants will call and just want to book kind of a consult time to kind of plan and talk about something, a difficult situation. Other times they'll say, hey, I just want to ride along. I'll refer the client to you. I just want to sit and just watch and learn. And I've got no problems with that. And they say, Mark, you can take the fee. I just want to sit along and watch. And then they'll have access to the precedents and the things that we do. So then they can go and, continue on with their journey. So it's very varied for sure. Yeah.
And it's great because it's part of what we were talking about when we were starting, right? It's about sharing the knowledge, growing together. You get more clients on your side, but you're also mentoring other people to learn on the process and then be able to do it themselves. And the ultimate goal here for everybody is basically supporting people who need to immigrate to Canada in one way or the other. So I mean, I think it's a very valuable contribution that you can not only do your own applications, but rather work with other practitioners who are doing their own to be learning. So I mean, that's great. So I'm going to ask our marketing team to share the information of Mark's website. And in the website, you can reach out to Mark for any information that you require, and setting up a call with him. So you can do that. So right now it's 12. We have Q&As. So we're gonna go past 12 to answer a few of those. We're gonna check the questions that we received when you registered, and also some of the questions that are in our questions tab as well. So let's go. I see a question from Megan Bissett. It says, "Hi, what is the minimum investment amount for a subsidiary company starting in Canada?"
Yeah. So this is a moving target, because it doesn't matter if the government says, well, you need 50,000 minimum investment because you're really you're a software-based company. There isn't a need for a big manufacturing facility that's developing widgets and things like that. So lots of people ask what that minimum investment is, and I'll be honest, I tell them as much as you can put in. And this is where Joorney also helps too when it comes to developing your business plans. But think of it as a sliding scale. The least amount of investment that you put in, the far greater it is to be able to get that work permit. And I have had situations where, small entities have demonstrated that there is sufficient funds to support the individual transferring, and that's a key component, because the minimum investment has to demonstrate how there is resources to support the company as they're establishing, that it also can support the wage of that individual you're transferring at a prevailing wage rate. And as you start to drop down, you can imagine a senior executive that's transferring, and if you look at go to the job bank and look at the wage, at least the prevailing wage for 00 NOx, and they're going to Toronto, it's going to be over $100,000 in most cases for that position. So at a very bare minimum, well, you're not going to be going under 100,000, right? So those are the things. That's how you need to approach it. Not what's the minimum, but what is a real viable plan that we could put in place to demonstrate to an officer that what we're doing is going to be successful, and that it's not just for the purposes of securing an immigration status for that person being transferred. So, and the funds have to be there to support the parent and all of the operations, and that parent operation has to be continuous. It has to show that it's continuing forward. The person is here to transfer, and and with a startup situation, typically managerial positions are the ones that are driving the ship. The entity really needs to be set up almost. Rarely is it going to be that you're going to send in a specialized knowledge worker to do a startup for your company as you're establishing a new presence. So, and Joorney, they've got lots of experience helping people to develop those plans and to kind of brainstorm, but it needs to make sense from a business perspective.
Thank you for that, Mark. In related to that, we're talking about the investment, but I have a couple of questions that are in the same line. In order to have a strong application, does the Canadian company need to have a bank account open with a significant deposit?
Yeah, well, that's a good question. So this always comes down to the specifics, and you can't just answer that as yes or no. If someone was to say, hey, I have a choice to having a bank account with a whole bunch of money in it that's for the company that's being established in Canada, and it's sitting there, versus no, well, guess what my answer would be? It would be absolutely, of course. But there may be circumstances, and the program delivery instructions actually address this, where the parent company is really driving the ship because it's going to take time to get the company set up on the ground. And in some instances, they even talk about the physical premise of the entity, because obviously once the company is incorporated, there needs to be a registered office, and often that's council's address. Well, the program delivery instructions actually acknowledge that, at that stage, there may not be a lot on the ground, and that's why they issue only one-year work permit to see how the plan actually comes to fruition. So is it better? Yeah, it always is. 100% to have funds actually available for the company in Canada. Because if I was an immigration officer, I put my hat back on and I think, okay, well, are they really serious about setting this business up? Are they really serious about the this business being successful, or is this just purely to get, you know, Jose here to Canada and to be able to go through express entry, right? And then they're going to fold it all apart, because the whole goal here is international competitiveness and helping the economy in Canada. And that's why the program, that's why the you know, the intercompany transfer works.
Definitely. I have a couple of questions. People are interested in knowing the IRCC regulatory changes that you were mentioning about, the ones that are coming up in September, where they can access them.
Yeah, so so I've got a little slide deck here, and basically these regulations were made, they were published in the Canada Gazette, and I can, let me just see here. I wish I could just, I wonder if I can post the link. I wonder if I can, here, I'll post the link.
On the everybody chat, you should be able to.
Okay, let's see if I can find the chat where there's 78. Okay, so what I'm going to do is I'm just going to post it right in. So that's the Canada Gazette right there with the provisions and the changes. And so you can go through that and take a look, and that just describes what's happening. And these are going to become, they're coming into force on September the 26th, 2022. And essentially, to just boil it down, it's that there needs to be a signed contract before the job offer is registered. So that's essentially what it is. Signed by both parties. The elements of the contract are consistent with what's being put in the job offer. And it's just one other indicia that IRCC can use to audit your companies after. And if you don't do it, then they've actually set out monetary penalties, and they've classified what type of non-compliance it is, and subject to fines. So yes, hopefully that works. I think everybody should be able to see it.
Thank you for sharing, Mark. I have a few questions. There's some that I'm not replying because we've already touched on them, and like I said, everybody's going to receive the recording, so I'll try to get the ones that we haven't discussed maybe. I have a question from Calvin Bowie. If an employee returns to work for the overseas company, does he or she need to be on payroll for 1 year before he or she can be transferred to the Canadian company?
Okay, read it one more time so I can get it.
If an employee returns to work for the overseas company, does he or she need to be on payroll for 1 year before he or she can be transferred back, I guess, to the Canadian company?
Yeah. Well, think of it this way. An individual has to prove evidence or provide evidence that they have been working for the foreign entity for at least a year before they can transfer back. So what I'm reading through the lines is that maybe they'd reached the cap. You know, maybe they'd capped out, and once you hit 5 years, and this is something we also didn't talk about, once you reach the cap of 5 years or 7 years, then you have to be outside of Canada working for the company abroad for at least a year before you can then come back. Because think of it like resetting the clock. So if they're actually not on payroll with the overseas company, then how do you show that they've been employed continuously for 1 year, which is an essential component of being transferred back? So yeah, the short answer is and maybe there's some scenario or something that would be, you know, that I'm not thinking of, but I can't see how you could do that without them actually going back on payroll and actually working for the company abroad. And yeah, so that's my thought on that.
I have another question. As well as being senior executive, does the manager transferring to Canada need to have an ownership of the parent company? No,
not at all. So it does not have to, that connection doesn't apply at all. Senior executives, managers are employees. They can be owners. They can have, you know, stock options and things like that with the company. But there's no link between that at all. No, they're two separate assessments. Yeah.
Okay. Have you seen, Jade Calver asks, have you seen applications that are relatively large revenue wise, but that just have one employee, the executive, be approved?
Well, think of it this way. If the company itself only has one person, it will never, ever, ever work, because you can't transfer from your entity abroad to Canada unless there's someone in the foreign entity keeping it afloat. So by its very nature, I've never had a situation, even if it's $1 billion company, the money is irrelevant. It's more being able to show that you're transferring from an existing going concern, you know, business to an operation that is also functioning and working. And so unless you have people actually working and managing, immigration will never treat that as a transfer, even though you can maybe do things virtually and keep that other company afloat. It would be very, very difficult to be able to demonstrate to an officer that this is actually a transfer in that situation. Now, like I said, anything could happen. Anything could happen. But personally, it would be really hard. And I want my application to appear as closely as possible to the most routine standard transfer that exists. So, and what is it? Routine transfer is you've got one company with a bricks and mortar operation in, say, the US, and you're transferring an employee because they've got unique skill set to another operation that's a wholly owned subsidiary in Canada. They all do the same thing. They're a global presence, and this individual is transferring in a similar position to bring their skill and knowledge, their specialized knowledge in some cases, to help the Canadian operation understand those aspects of the company that are just idiosyncratic, that just can't be, transferred unless a live human being goes and works and helps to set things up. So that's really the critical aspect. So I'll try to do everything I can to try to create that type of a scenario for an officer. Obviously, I'm not going to make things up that aren't there, but that's where I'll want to try to point, the lens when an officer is assessing the genuineness of this transfer.
Of course. And it all goes back to the immigration strategy. And that's why we always encourage applicants to have a support of an immigration professional, because sometimes people want to do their own. And yes, I mean, in some programs, it's a possibility, but then you lack this immigration strategy out of experience that comes with the profession.
Yeah.
I have another question. Go ahead.
I'll just add one other thing. Like I alluded to in the very beginning, if you go to the website, you go to your online, your representative portal, and you say, I want to apply for a work permit abroad, and you follow whatever the guide is, the checklist that's right there, you are never going to be successful because of the other, like all of the missing pieces that form the real core essential components to this. Correct. It's that employer letter that is the single most important component. And there's just kind of a passing reference with no real instructions on what the letter is supposed to look like. So you have to go back to the program delivery instructions and then see the elements that they're looking for and bake those right into the wording in your letter. So if it says they need proprietary knowledge, then I'll say, this for national, this transferee has proprietary knowledge at an advanced level of this, whatever it is, the way we do things that's idiosyncratic to our company, and there's no one in Canada that can do it, and this is why they're being transferred. So yeah, you really have to be willing to do the work.
Wonderful. I have a question from Alisa Amir. Alisa is asking, does the immigration officer have any preference for IT companies nowadays compared to other businesses?
Well, okay, let's take India, for instance, okay, where for years before, I think it was, how far back was it? Maybe 2014, as far back as 2014, they didn't pay too much attention to what, the wages that were being paid when people were transferred to Canada. And, and obviously India, there's a large number of individuals that are being transferred for IT purposes to Canada. And once again, they were being transferred and they were being paid lower than what Canadians would be paid. And this was right in the midst of an overhaul of the temporary foreign worker program and the other programs. And they said, wait a minute, how is this fair? And it actually, and I'll have some fun telling flashbacks, RBC had outsourced some of their division to a company in India who had then set up an intercompany transfer where they transferred their people to Canada. And the RBC employees that were being terminated were training the contractor to take over this process that had been outsourced. So it was a real black mark. And so Canada says, wait a minute, no wonders Canadians are losing jobs because they're able to bring people in at lower rates. And so IT kind of got a little bit of a black mark. And so then they started to be scrutinized actually more. So yeah, then regular transfers just because of that. And so I think that holds true to some extent today. And one other thing I will address, you asked, okay, what are some of the areas where things can fall apart? Specialized knowledge and being able to demonstrate it. And if everybody in your company has that specialized knowledge, that person ain't very special. And often with IT companies, because you use, fancy terminology and things like that, that can sometimes officers' eyes glaze over. When you have a company like that, you really have to go the extra effort to show why this person's particular skill sets and knowledge, specialized knowledge, is not something commonly held throughout the company, and in particular in Canada. And so they will often scrutinize those even more, just because of the high numbers of individuals coming through that are in that industry. Probably it dominates intercompany transfers to a large extent, especially coming from India.
Thank you, Mark. We have a question from Anurag Sharma, and I think we're going to do a couple more, maybe from the ones that we received weren't registered, and then we'll try to also send Mark some of the questions to see what's left there. Maybe we need to do another one.
Yeah,
another webinar to be able to answer. Yeah. Is a C11 work permit for NOC 00 also considered to be 200 points in express entry?
Yeah, so this is really an express entry question versus an intercompany transfer, and C11, the kind of entrepreneurial type of work permit, it doesn't matter what the work permit is as long as it is employer specific. So for the purposes of the offer of employment section within the comprehensive ranking system, those extra 50 points or 200 points are available for option 3. So there's 3 different ways you can hit that job offer standard, is to have worked for a company in Canada for at least a year, and it's an employer specific work permit. So that's what drives the ship. So it's not so much whether they're coming in at C20 or C12 or C11, which are all employer-specific work permits under the International Mobility Program. It's just those that are in open work permits with no employer that it doesn't matter. They can't qualify for those extra points.
Okay. Selena Fan asks, how long can a transfer staff be absent from Canada?
Okay, so think of it like my parachuting example, where I have executives that are working for a U.S. company. I do a lot of engineers, architects, consultants, healthcare and other industries, and they are constantly parachuting in. Now, where possible, I will use CUSMA, an AFTA professional permit, but if I have an intercompany transfer, then the work permit is issued, and that's why the whole recapturing is possible. Because a person comes in, they work on a project, or they're actually taking up a position though, and then once that's done, they go back to the home branch, and their work permit's still valid, and then they'll travel back again. And so there is no set time frame for how long they can be outside of the company. You just want to document it all, and you just have to be careful, and it's different for every situation. If the person is not in Canada, under the International Mobility Program, you need to just make sure that you document it properly, because when an audit comes, they will want to see payroll for that individual throughout the course of the work permit. And in some instances, payroll may be coming from the foreign entity because they're on payroll there. And then there are separate, agreements that you put in place to transfer back or things like that between the companies to compensate for the wages that are being continued to be paid by a foreign entity when the services are provided by the related affiliate in Canada. It becomes complicated. It becomes a little bit more complex, but yeah, the short answer is there's no set time how long you can be in or out, and yeah.
Perfect. Heather Menaglio asks, and this is going to be my last question from the audience, and then I have one more myself. Where is the best place to gather information on the prevailing wage in Canada? Heather asks.
It's the job bank. So that's the source of all goodness, you guys. For the purposes of this IRCC assessments, the job bank, when you go to the job bank, there's all of the wage data is right on there for the positions, and you can go by location, and it makes a difference if the person's transferring to Toronto versus Vancouver versus Calgary, or wherever, Miramichi. It ultimately that's where you can get your data.
Wonderful, Mark. So just to wrap up, because we know that you're a very busy person and you have a lot of work to do.
We're all busy,
ICTs to
Marianella.
file.
All these people who took the time to join this are super busy too, and I appreciate them actually coming and listening to me, taking time out.
Definitely, Mark. So just to wrap it up for them and for us, final remarks, general advice for ICTs, for everybody who's listening.
Yeah. Always put yourself in the shoes of the officer. So when you're preparing an application, think before you choose to take it on for the client, and think to yourself, if I present this to an officer, do I think that they're going to buy it, right? Are they really going to see this as a true transfer, or are they going to see it more as someone who's just trying to get a job and get work experience in Canada so that they can qualify for express entry? That's really the first most important step, is to do that test. So don't just take it just because, you know, it's extra revenue, but be wise, because if it doesn't work, right? If you try to push something forward that really doesn't have a hope, the client's going to be upset, you're going to be frustrated, and it's just not a path that you want to go down. But with that being said, your job is to advocate. And if you believe that, you know, this is a genuine transfer situation and maybe some aspects of it aren't as strong, well, that's where your role as a representative comes in. Your job is to really take the time to understand the business, especially when you're trying to craft a specialized knowledge argument. One of the things I love most about intercompany transfers is that I learn all this stuff about these cool companies. You know, maybe they've got new technology, maybe they've got some patents. Oh, I love patents; those are great. And I learn all this about different businesses, and then I get to put it together in an employer letter of support that basically explains to the officer why this person is so fantastic and how they're going to change the world in the company, you know, when they transfer to Canada. So, yeah, so do your work. I keep saying that. If you take shortcuts or you leave it to your support staff to try to put it together, it's never, ever going to be successful. You're the ones with the expertise, and you need to have your hands on this stuff. It's not something that can be delegated to the same extent.
Definitely, Mark. And of course, you can always refer back to all the resources that we've been mentioning. You can reach out to Mark, get his support if maybe you don't feel the full confidence of taking over an ICT application. So yes, that's it. Thank you so much, Mark. We are very, very grateful for all our partners, everyone who has supported us since the beginning and throughout time, which includes you, Mark, and also everybody who has participated today in this webinar. Thank you so much, Mark, for accepting our invitation to be part of our webinar.
Absolutely, my pleasure.
Thank you. Thank you, everybody. See you next time. Bye.